Judicial system of Japan. In the judicial system of Japan, the Constitution of Japan guarantees that all judges shall be independent in the exercise of their conscience and shall be bound only by this Constitution and the laws. Article 76. They cannot be removed from the bench unless judicially declared mentally or physically incompetent to perform official duties. And they cannot be disciplined by executive agencies. Article 78. Supreme Court judges, however, may be removed by a majority of voters in a referendum that occurs at the first general election following the judge's appointment and every 10 years thereafter. The judiciary was far more constrained under the Meiji Constitution, that is, under the present Constitution, and had no authority over administrative or constitutional law cases. Moreover, the Ministry of Justice had complete and direct control over the court's administrative affairs. Nonetheless, Professor John Halley argues that the courts maintained complete independence in the adjudication of particular cases. Judicial independence from the political branches was emphatically established as a fundamental principle of governance in Article 57 of the Meiji Constitution. Of all branches of government, only the courts exercised authority in the name of the emperor. Halley argues that this was and remains a matter of great pride for Japanese judges and notes that placed prominently in all courtrooms was the inscription in the name of the emperor as a meaningful reminder to imperial officials and subjects alike that the emperor judges were not subject to political control or direction. Tokyo High Court. A key feature of Japanese courts is the emphasis on the wakai settlements by mutual agreement of the parties who no loser or winner. These settlements have the same effect as a court judgment. Code of Civil Procedure, Article 267, Civil Execution Act, Article 22. For example, in 2016, the District Court issued 63,801 judgments and orders, and 52,957 claims were solved by wakai settlement. In the summary courts, the numbers were 186,808 and 40,509 respectively. Historically, courts in Japan were following the inquisitorial procedure. For example, in a Shirashu court in the Edo era, where the chief magistrate, Bagio, was also the prosecutor. After 1890, Japan was influenced by the European inquisitorial system or style of French and German law, where judges and the prosecutor had the responsibility to find a fact and apply the law. After 1948, the courts in Japan were influenced by the American adversarial system. In 2021, similar to the previous year, Japan ranked 15th in the World Justice Project's Rule of Law Index, placing the country third among the G7 economies. Courts. Japan's court system is divided into four tiers. At the first, lowest of the four tiers of courts are the 438 summary courts, Kani Shaibanshu, staffed by 806 summary court judges. Summary court judges are not career judges. Qualification as a regular judge is not required. Instead, summary court judges are formally nominated for pro forma cabinet appointment by a special selection committee formally comprising all Supreme Court justices. The President Chukan of the Tokyo High Court, the Deputy Procurator General, representatives of the bar, and others with special knowledge and experience. They mostly handle small claims, civil cases, disputes not in excess of 1,400,000 yen, as well as minor criminal offenses. They are also able to imprison defendants in a few special cases. Summary courts are presided over by one judge. Civil cases in a summary court are appealed to the district court, while criminal cases are appealed to a high court. Akita District Court. At the second tier are the district courts, Chiho Saibanshu, the principal courts of first instance. There are 50 district courts in the prefectural capitals, with additional 203 branches, except for minor cases, which account for 80 to 90% of all adjudicated cases. Trials require a 3-judge panel. There are the courts of general jurisdiction and the principal court of first instance. District courts have original jurisdiction in felony cases and in civil cases where the disputed amount is over 1,400,000 yen. They also handle bankruptcy hearing. Each district court trial is presided over by at least one judge. 2 associate judges are also called in for appellate cases, for summary or family courts, or for criminal cases where the maximum penalty would be in excess of 1 year in prison. Attorneys sit on either side of the courtroom, facing the center. In a criminal case, the accused faces the judges from the rear of the courtroom. The witness box is in the center, also facing the judges. There are 8 regional high courts, Koto Saibanshu. They Sapporo, Sendai, Tokyo, Nagawa, Osaka, Hiroshima, Takamatsu, and Fukuoka serve defined circuits of several prefectures each. There are also branch offices in Akita, Kanazawa, Okayama, Matsue, Miyazaki, and Naha. There also exists the Intellectual Property High Court, Chiteki Jaishan Koto Saibanshu in Tokyo, which is a special branch of Tokyo High Court. A high court usually sits in the same manner as the 3-judge district court. Each court is led by a president who is appointed by the cabinet. An appeal to the high court is called kushu. The high courts are appellate courts for either kushu appeals from district court judgments, criminal judgments from summary courts, or in civil cases tried initially in summary courts, second jokoku appeals in limited to issues of law. Osaka High Court. The prefectural district courts are administered under the regional high courts as follows. Takamatsu High Court, Shikoku Takamatsu District Court in Kagawa, Tokushima, Kochi, Matsuyama, in Eham. At the apex of the judicial hierarchy is the Supreme Court, Saiko Saibanshu, located adjacent to the National Diet Building in the Nagatacho district of Chiada, Tokyo. The Grand Bench Daihatchi of the Supreme Court has associate justices who are appointed by the cabinet with the emperor's attestation. The Chief Justice is nominated by the cabinet and appointed to office by the emperor. The Grand Bench is subdivided into three petty benches, shohei, of 5 justices each, who hear incoming appeals and recommend them for an audience before the Grand Bench. An appeal to the Supreme Court is called jokoku and requires either an error in the interpretation of the Constitution or an error in the interpretation of case law from the Supreme Court or a High Court. In addition to this strata, there is also a family court, kate seibanshu, tied to each district court, as well as in over 200 branch offices throughout the country. Family courts primarily deal with juvenile delinquency cases and divorce, although they have a broad jurisdiction that encompasses all forms of domestic disputes, including correcting koseiki registration data and partitioning estates. If a settlement cannot be reached between the parties, the case is transferred to the district court. Although juries have not been used in Japan since 1943, a new quasi-jury system was passed into law in May 2004 and was implemented in 2009. They are not juries but lay judges, saiban-in, working side by side with the professional judges. Typically, there are 6 lay judges and 3 professional judges for one case. The decision has to be by majority and include at least one of the professional judges. Such saiban-in trials are only used in serious cases such as those punishable by death penalty or life imprisonment and cases that caused a victim to die. This is provided in the Act on Criminal Trials with the participation of saiban-in. Thank you, viewers, for watching.